This is LXBN TV, and I'm Colin O'Keefe. Suing companies for running credit checks on potential employees has become a big priority of the EEOC. That recently happened with Kaplan Education, and the suit was tossed out. The EEOC eventually appealed, and things got even worse for the commission, as the Wall Street Journal recently called it the opinion of the year. Joining me now to explain exactly what happened is our resident EEOC expert, that is attorney Jerry Maatman with Seyfarth Shaw, and author on the firm's blog, the EEOC Year-End Countdown. Jerry, first let's start as we normally do with the background. What are the details of this suit? What exactly happened here?
This was an interesting case, and I actually served as defense counsel. The government sued Kaplan, a private employer, with respect to its use of a hiring screen, where Kaplan would run credit checks on people who applied for jobs that would handle money, in particular financial aid officers who would deal with students over loan issues. The government contended that that practice had a disparate impact against minorities in general and African Americans in particular, and it sued Kaplan on a nationwide basis involving its use of this hiring screen over a series of years. What was very important and critical in the case occurred actually in 2013 when, for the very first time, the court allowed Kaplan, the employer that had been sued, to actually take discovery from the government about the EEOC's own employment practices. We had raised an issue called government estoppel. How can the government do something as an employer and then sue a private employer for the exact same practice? And we contended that because governmental attorneys and personnel were issued government credit cards, more likely than not, they went through a screening process or even a background check. The judge said, I agree, and allowed Kaplan to discover what the EEOC did in terms of its own personnel practices. Later in 2013, we brought a motion for summary judgment on various grounds, and the court granted it because the district court granted it because the EEOC was unable to prove any disparate impact because the expert they used didn't engage in a methodology that passed the Daubert test. And then the case was appealed and even got more interesting.
Yeah, absolutely. This has been an eventful and entertaining case all the way through. So second, let's talk now about the impact of this. What is the takeaway for employers?
Well, the Sixth Circuit issued its decision a week or so ago, and in very caustic and strong language criticized the government both for the deficiencies with its expert study and for its systemic litigation program in terms of suing an employer over a practice that the government itself engaged in. So as employers look forward, the EEOC continues to focus on hiring discrimination as the number one area it litigates. Obviously, the systemic nationwide lawsuit is the type of lawsuit that all employers are worried about. The Kaplan decision will probably set the die and put the EEOC back on its heels for some time, and it remains to be seen whether or not the EEOC will rethink its litigation philosophy. But it certainly does seem that insofar as challenges to hiring screens involving credit checks, the Sixth Circuit put the nail in that coffin a week ago with its decision.
Absolutely. We'll see where things go from here, but as you mentioned, this really casts quite the die on what the EEOC is trying to do. Once again, that is Jerry Maatman of Seyfarth Shaw. Be sure to visit his blog. It is again at EEOCcountdown.com. Thanks for joining me, Jerry.
Thank you.